We are charged on case of offensive conduct, conducive to breaches of peace, Section 94(1) of the Penal Code. Translated from Kikuyu to English. I'm telling you the truth. If in any area we get even one vote for Kasongo or his followers, I'm begging you, we will follow you and get you under your belt. Because we must keep a record of those people supporting that man. We cannot, for no time, we allow that after what he did to Rigadi and all the things he has done against us, including killing our children, and then we support him. If you support Kasongo, then if we speak honestly, if you get, we will not mourn with you. If you have a dowry event, we will not receive those goods. We will take them to Sugoi. You get sick, we will go to get Shah in Sugoi. We intend to provoke or breach or the peace. Is it or not true?
Yona, perhaps, because we can hear slightly what she's reading, but my request is that she can read through the mic so that all of us can hear, because we don't have enough copies of the charge sheet.
She can take it again.
That is in order.
Yeah.
Yes, I can do it. John Philip Bishoi, a teacher. You are charged offensive conduct conducive to breaching of peace under Section 94(1) of the Penal Code. The particulars are translated from Kikuyu to English. I'm telling you the truth. If in Kieni area, we get even one vote for Kasongo or his follower, I'm begging you, we will follow you and get you under your bed, because we must keep a record of those people supporting that man. We cannot, or no time will we allow that after what he did to Rigadi and all the things he has done against us, including killing our children, and then we support him. If you support Kasongo, then if we speak honestly, if you get believed, we will not mourn with you. If you have a dowry event, we will not receive those votes. We will take them to Sugoi. If you get sick, you will go to get Shah in Sugoi. We intend to provoke a breach of the peace. Is it true or not true, Mr.
Wait.
May please, Your Honor. I have instructions from the accused person that we do object to him taking plea. And maybe before we proceed, Your Honor, allow us to introduce ourselves. My name is Wakili Edward Mureu. I'm a member of Parliament for Gataka constituency, but I'm here as the lead counsel for the accused. Lawrence Karanja.
Present.
Kirago Waduta.
Present, Your Honor.
Degwanjiro.
Present, Your Honor.
Ndego Watuta.
Degwanjiro. Collins Osewe.
Present, Your Honor.
Ndego who? Ndego who?
Jiro. Collins Osewe.
Present, Your Honor.
Boniface Nyamu.
Present, Your Honor.
Sasha Wamae.
Present, Your Honor.
Andrew Muge.
Your Honor, present.
Honorable Jerry Minor.
Present, Your Honor.
Dan Maanzo,
Present, Your Honor.
Bernard Derito,
Present, Your Honor.
Kariuki Njiri, Honorable Mark Mwenje,
Your Honor, present.
Simon Mboro,
Your Honor, I'm present.
Wangeshi Wahome,
Present, Your Honor.
John Jomo,
Present.
Ishmael Nguringa,
Present, Your Honor, and my name Guringa has an apostrophe. It's a Guringa.
and Mr. Wanjohi.
Present.
Your Honor, with your kind permission, before we lay the grounds of the legal position on why we have instructions for our client to take any plea, I just want first and foremost to lay the background under which this matter has found before you. Your Honor, on the 2nd of August 2026, the accused, John Philip Yeshohi Kaguchia, a member of Parliament elected by the great people of Mukurweini constituency, and in his capacity in executing duties and responsibilities which has been given by the people of Mukurweini, he was invited by the royal media in Noro, a program called Kiririmbi, which is owned by Royal Media Services, to discuss matters of this country. With him, he was with other members of Parliament, again executing their constitutional duty of creating awareness of the matters of this nation. The program started at 7 o'clock, 7 p.m., ended at about some minutes to 9.
Started when?
Started around 7 p.m. and finished at about 9 p.m. When he was on his way out, he was alerted by the members of staff of royal media about the presence of about 30 Subarus which were being driven, or rather, there were about 50 hooded men claiming to be officers, police officers.
Said they were 50 and they were hooded.
Hooded, concealing their faces and their heads, who had surrounded the area around Royal Media Services. Your Honor, he was advised that those hooded goons, who are not officers, not in uniform and no identification, were inquiring whether he has left the station. When that happened, Your Honor, the accused called me and advised him to remain in the premises because nobody can be able to identify who those hooded goons were, their intention. In particular, Your Honor, in this sad age of abductions and killings in this country. At 5 a.m., Your Honor, I personally proceeded to the Royal Media offices and found the accused, who had to spend a night in the couches waiting for the sunlight, hoping it will help him. It was about 9 a.m., Your Honor, that one gentleman with a group of police, uniformed police, by the name Kandie, who came and introduced himself as the regional officer in charge of DCI and proclaimed the accused to be under arrest. The other is important that I point out that all this time around, the accused, nobody has sent to him either summons to appear before lawful authority, neither was there any warrants issued against him. And upon our inquiry from the arresting officer on why the accused before you was never served with summons to appear, or the presence of warrant of arrest. As usual, they said they are acting under instructions from above. Your Honor, I advise my client, the Honourable Member of Parliament, to comply now that the officers have identified themselves. And I asked the officer where they are taking him. They lied to me that they are taking him to regional offices on Kilimani Road. But by the grace, we followed the car, and the accused was dumped in DCI headquarters on Pembu Road. Along the way, Your Honor, I requested Counsel Dewanjiro to accompany me and other lawyers it's only myself and Dewanjiro were able to get in before instructions were given not to allow any other counsel within the premises of DCI. Your Honor, even when the accused was under hands of the DCI, the two counsels were denied access for consultation and all the other lawyers were locked out of DCI headquarters. The drama did not stop there. The lawyers went to court and obtained bail in case number HCC miscellaneous application E70/2026. The accused was granted bail and requested to pay 100,000 to be deposited in police cash bail in Kamukunji police station.
So they paid the cash bill to Kamkunji police station.
Sorry,
Where is the cash bill? You're saying the Kamkunji police station. That's where the cash bill was paid.
that's where the accused was held because he was taken back, he was removed clandestinely from DCI and taken to Kamukunji. That is now the 3rd of August 2026. Your Honor, upon prevailing the OCS of Kamukunji police station to release the money and release the accused, he started playing cat and mouse game
So he was to release the accused and? You're asking him to release the accused and who? Or what?
He's only the accused, Your Honor. There was only one accused, one John Philip Kaguchia.
Proceed.
Yes, until late in the night, when he owned up and said, no, I've been given instructions, you either go and take the money to Central Police, otherwise I have no instructions to release. Your Honor, we even read the penal notice to him for disobeying the court order. And John Kaguchia has found himself before this court with a court order bearing the bail that he was supposed to be released yesterday. But the OCS Kamukunji denied and refused even to take the cash bail. Your Honor, why I've had to spend a bit of time to lay the basis, and I'll give my line of friend over here to highlight the points of the law. Is purely because the accused rights under Article 49, Article 48 of the Constitution has been trampled upon. The state, in its wisdom or lack of it, it decided it will share of the law and produce a drama of arresting a member of parliament. Therefore, Your Honor, we find it unjustifiable. The accused is not before you because of crimes committed. He is before you to demonstrate to the world and all voters in Kenya that it is a crime to oppose the governing power. The use of goons to come and arrest the accused and avoiding summoning him before the authorities or obtaining warrants is a transversity of justice against the accused, and therefore, Your Honor, this matter need not find itself before you because whoever comes for equity must come with clean hands. Your Honor, I wish to request the learned friend, Mr. Aduta, to highlight on a few points of law before I pass on to the 1-0. Thank you, Your Honor.
Yeah. My name is Kirago Aduta, you know, and very briefly. You know, after disobedience of the court order that my learned senior has highlighted, the accused person further went to the High Court in High Court at Milimani in a different matter, you know. High Court Human Rights Petition number E517 of 2026. Ediona, this morning, His Lordship Justice Gregory Mutai granted him free bond. So the cash bail of 100,000 was disobeyed yesterday. Today we have an order of free bond, which again was flouted. You know, in both of those two proceedings, and you will look at the orders, both courts are saying that order number 4 in the first order and order number 3, actually number 2 the DCI and the IG of police are being told, allow this person to access his advocate, because that right has been denied since Sunday night. All these lawyers you see here have not had access to the person who is seated there. He has not received any counsel. And the courts are saying, allow him to seek counsel. So charges are being read to someone who has not sought legal advice. Again, contrary to Article 49, Sub-Article 1, Paragraph A, Roman 1, no, sorry, paragraph sub 49(1), paragraph C, where he has a right to communicate with an advocate and other persons whose assistance is necessary. That has been denied. That's the person who is before you. And the courts have said he's been denied. So it's not mature for that person to take plea before he gets advice from counsel. You know, I have had a look at the charge sheet, and in the particulars, it says that on the first day of August 2026, at Narumoro Shopping Center within Kieni East Sub-County in Nyeri County. Now, those things were said to have been done. Yona, this is Nairobi County. The territorial jurisdiction of these matters that are stated in this charge sheet are in Nyeri. This is the wrong forum that we are appearing before. So in terms of territorial jurisdiction, we are in the wrong forum. Offenses to be tried by a court within which the offenses are alleged to have been committed. That point, in a court of law such as this one, and the courts have said this over and over again, I'm sure Mr. Degwajiro will highlight this, that is not a conveyor belt of processing any charge sheet that is brought before it, even when that charge sheet does not disclose any offense. The offense or the section under which this charge sheet is brought is section 94, subsection 1 of the Penal Code, that I do not wish to read it verbatim.
Under section?
Section 94, subsection 1 of the Penal Code. And wait, kindly allow me to read a part of it. It's very short. It says that any person who in a public place or at a public gathering uses threatening, abusive or insulting words or behavior with intent to provoke a breach of the peace or whereby a breach of peace is likely to be occasioned is guilty of an offense. Turning to the charge sheet, it only says that on 1st of August 2026, at Unarumoro location, knowingly and intentionally used words in Kikuyu language to it, then the words are written there. There is no allegation that these words were made in a public place or at a public gathering, or that the words were threatening, abusive, or insulting. And it is therefore the location where the words are said to have been made is a very vital ingredient before such a charge is sustained. So therefore, the court should not entertain a charge that will not take us anywhere. Let us save judicial time. They can amend it if they wish to. The last point that I want to address, and it is tied to where I started. Yona, it is not contested that the accused person has been in custody throughout. He has actually been escorted to where he seated. 2 nights he has spent in the cold. And Your Honor, looking at the section under which this charge is brought, the punishment for the offense under this section is a term not exceeding 6 months or a fine of not exceeding 5,000 shillings. Your Honor, Section 4 of the Penal Code defines 2 kinds of offenses. One is called a felony, and another one is called a misdemeanor. You know, a felony is where the punishment is 3 years and above, and whatever else is not a felony is a misdemeanor. Meaning any punishment below 3 years is a misdemeanor. Therefore, the offense under which the accused person is charged falls squarely within the definition of a misdemeanor. You know, Article 49, Sub-Article 2 of the Constitution states as follows: a person shall not be remanded in custody for an offense if the offense is punishable by a fine only or by imprisonment for not more than 6 months. If the imprisonment is not more than 6 months. You know, this is not a regulation, it is not a statutory provision, it is not a judicial pronouncement, it is a supreme law of the land. It is a constitution. Article 49, sub-article 2. Today you have a person who is charged with a misdemeanor and who has been in custody for 2 days. And he's now brought before you so that you validate the gross violations of his constitutional rights. By allowing him to take plea in these proceedings, despite all these violations, lack of contact with counsel, having been detained without accessing anybody, it is the wrong court. Instead of Nyeri, we are here. Yona, this will be the gravest form of violation of the rights of an arrested person. Kindly decline to take further proceedings and let the Honorable Member of Parliament for Mukureni to continue with his legislative duty.